Hi, Mike Brinley, auctioneer. I also recently published a blog concerning immunity. Could an auctioneer conceivably put in his contract, I'm immune from a lawsuit or prosecution or any claim against me? Could that waiver stand? And I think not. I don't think you can keep people from suing you. There's even, mandatory arbitration or mediation and things like that in contracts, but largely, even when somebody signs that they agree that they won't sue you but go to mandatory arbitration, then an attorney will find a way to start a lawsuit. And so there's virtually no immunity for auctioneers, despite what your terms may say. Now, terms can, I use this term, I think it's fair, bluff. In other words, put in your contract, you can't sue me. You have to submit to mandatory arbitration. A client may, a buyer may look at that and say, I guess we can't sue. I guess we'll have to go, and thus your bluff worked. Are there other kinds of immunity? There are. The President of the United States and I believe his cabinet and probably Congress and Supreme Court justices and the like have what's called absolute immunity. They can't be sued while serving in their official capacity. And I think that's probably a good idea, because if not, people would be suing the president or suing the Speaker of the House or suing, senators, Congress people, the Supreme Court. They'd be suing them every day, every minute of every day. And so they're immune from those types of cases while they're serving in those various capacities. I think that's a great idea. We have another concept in our country at the moment. I sense some winds blowing to change this, hope so, where police officers have what is called qualified immunity. Qualified immunity. And qualified immunity is, if I'm, as I understand it, if I'm a police officer and I'm going after a suspect and I shoot him or I tackle them or beat them or whatever, I'm immune from a lawsuit or from possible consequences of that action if that particular action hasn't been litigated before. And several attorneys and even one Supreme Court justice has said that creates kind of a catch-22. In other words, if the police officer with qualified immunity is doing something and there's maybe a cause of action, well, if that cause of action hasn't occurred before, it can't happen this time because the officer wouldn't have known that that was maybe unconstitutional or bad behavior. But if you can't get that case in there, then there'll never be a case like that, which means that no other case like that will have a case prior like that. Tails, I win. Heads, you lose. Kind of. So that law needs looked at seriously. We have Sotomayor on the Supreme Court saying that law is unconscionable. I don't know that she used that term, but that was my impression. Clarence Thomas has pointed out that he's not sure where the law came from because he doesn't see anything in the Constitution about it and doesn't see anything else in writing about it, doesn't see anything from Congress about it. How did a court create law, state law or common law? Interesting question. Some attorneys say courts can't create federal law or common law, and others say they can. Apparently they did. Clarence Thomas would say they did. He wants to get rid of it based on that. So, here's the solution. I mean, every one of us as auctioneers are subject to lawsuits and complaints and unhappy people and, people seeking compensation, or, the more successful we are, or more money we make, and, we're in the big house with a big belt buckle and the Rolex watch and driving the brand new pickup truck. We kind of bring it on ourselves. They say, well, I injured myself, maybe, at your auction. I'm going to sue. Maybe you'll write me a check. People sue Walmart every day. People sue General Electric every day for just hopes of a settlement. so to speak. And so tort law, are we rampant with tort law? We're not like we were in the 80s and 90s. We've seen a sharp decline in tort law around the United States, tort law claims, rather. And so, we're all subject to getting sued. We can put in our contract or in our terms and conditions, you can't sue me, but you can still get sued. You can not have it in your contract or terms and conditions that you can sue me and you can still get sued. You can claim immunity and you can still get sued. What's the answer to getting sued or not getting sued is probably mostly good behavior. In other words, ethical, having integrity, fair dealing, acting reasonably, not citing a law and saying, well, I can do this. The law says that. We often talk about how the law and ethics compare and contrast. And the law seems to be the outer circle of we can't cross from legal to illegal, but ethics is that inner circle in that donut, if you will, the smaller hole. And, we kind of have to supplement what's legal with what's ethical, what's reasonable, what's fair, what constitutes reasonable, fair dealing with the public and with our sellers. And so, the better we behave, quite frankly, the better we behave. I know auctioneers all over the country that haven't been sued once, and not that getting sued makes you a bad person or not getting sued makes you a better person, but they don't tend to get sued because they operate their business in a certain fashion where people like them and they appreciate them, and they're personable, and their attitude and their demeanor probably helps them avoid some litigation. The other issue independent of that is if you're selling, if the last auction was a $5,000 personal property auction in the backyard, and the next auction was a $10,000 or $15,000 auction at a commercial establishment or another backyard for that matter, how much damage could there be? And maybe the potential plaintiffs in those cases say, well, he only had a $5,000 auction and he only gets 10% of that. That's $500. No sense suing him for that. Some plaintiffs, again, the tort law argument, some plaintiffs potentially look at the size of the deal and say, well, gee, it was a $10 million deal. They'd probably write me a check for $100,000 to make me go away. We see some of that in the big cases. We don't see a lot of small cases because you can't afford the attorney. You can't afford to sue. Big cases, $1 million. We've had cases as an expert witness. I've been involved in cases of 1 and 2 and 3 and 4 million, up to as high as 75 million, and everything in between. And am I ever surprised that somebody's suing for 46.5 million or 72 million or 75 million or 36 million or 12 million? I'm not surprised. Those are big numbers. And you sue for 12 million, you get maybe a settlement for 3 million. That's not a bad day. I'm not saying they don't have a case, but is that part of the reason we see those cases? I think so. The magnitude gets serious people involved as participants. And so you have people with means and money and access to legal and time, and they will, I've told auctioneers in pre-license, post-license, CE, all kinds of classes around the United States, you guys selling pots and pans, the old, I only sell pots and pans argument. One good thing about that is you're not going to be in a multi-million-dollar lawsuit because you're not selling multi-million-dollar stuff. Now, you auctioneers that are selling multi-million-dollar deals all the time, yeah, good for you. Absolutely. Do you have more risk of a lawsuit? You do, just by virtue of higher dollar deals. You're a bigger firm. You're a bigger target. Mike Brantley, Auctioneer. Pleasure to be with you today. Other videos on the same page, others forthcoming. Have a great day and stay safe.